Federation versus Freedom by Babasaheb Ambedkar. 7. Part 10. What would happen if Parliament did amend those provisions of the Act which Schedule 2 says shall not be amended by Parliament? The answer which Schedule 2 itself gives is that such an act will have the effect of affecting the accession of the states to the Federation, which means it will have the effect of destroying the binding character of the instrument of accession. In other words, if Parliament amended any of the provisions of the Act which Schedule 2 says shall not be amended, the princes would get the right to secede from the Federation. I am aware that some eminent lawyers have taken a different view. They hold that the princes, once they come into the Federation, cannot go out of it. I have mentioned my view for what it is worth, and I will say that my view is not altogether baseless. At any rate, the Solicitor General and Secretary of State gave the same interpretation as I am giving in the House of Commons when the Government of India Act bill was being discussed. The Solicitor General said, the states will not agree to federate in a structure which, within limits, is definite and certain, and obviously we could not completely alter the structure afterwards. The purpose of this clause is to lay down those matters which can be altered without being regarded as fundamental or as impining on the instrument of accession. If the structure were to be altered in fundamental respects, of course, the states would clearly have the right to say, this is not the federation to which we have acceded. The Secretary of State said, if you amend the parts of the bill which affect the states, obviously you would be altering the conditions on which they have acceded, and that would certainly create a situation in which the princes could rightly claim that their instrument of accession had been altered. It certainly means that we cannot amend any part of the bill which affects what is virtually the treaties under which the princes come in. If we make a change in the bill as to strike out the basis of their instrument of accession, then obviously the agreement has been broken between the princes and the parliament, and the princes are free. It will be accepted by everyone that under the general scheme of the bill, the states, when they are asked to federate, are entitled to know which, with certainty, certain aspects at any rate of the federation to which they are to accede. It would be an absurd position if you, having said to a state this month, will you accede to a federation, it was possible next month for this House to alter in some fundamental respects the provisions of the federation to which the state was held to have acceded. Therefore, some schedule of this kind is necessary. It is a sorting out of the various parts of the bill which should be capable of amendment without in any sense altering from the point of view of the states the constitutional machinery to which they have acceded. The scheme of the schedule is to set out the provisions of the Act, the amendment whereof is not to affect the validity of the instrument of accession of a state. One sees set out those parts of the bill, the amendment of which is not to affect the validity of the instrument of accession of a state, and on the opposite side, there are set out those subjects, the amendment of which would affect the validity of accession. In drawing up a schedule of this kind, one has to proceed with great care in defining what are the legitimate matters on which the rulers of a state are entitled to ask that there shall be no amendment without their consent. Of course, there will be borderline cases. There could be minor amendments which would not really make any great difference to the existing position, and it would be very unreasonable if the states took objection to such amendments and said, we are going to stand on our rights on this point as affecting the validity of our instrument of accession. It is right that any matter which really affects what I may call the general balance of powers, the questions of the reservation of subjects, of executive control, and of matters which can be dealt with by the Governor General in his discretion, matters which are vital to the architecture of the federation to which the states are asked to succeed, should not be amended without their assent. The whole area of the special powers vested in the government and the Governor General is one of the essential features of the federation. That is, one part where the states are entitled to say that is a change or that is altered. But this does not in any way check for all time the development of India. These are to be the subject matter of negotiations with the states, because in effect they will produce a federation of a different kind from that to which the state has acceded. The end.